Let's read a judgment together where in this case the court was so concerned about the father's behaviour and conduct post-separation that on day 5 of the final hearing the court made orders to flip the residence for the party's 12-year-old child to live with the mother and to spend no time with the father on an interim basis. So the father didn't show up to this day of final hearing and he was in the process of being cross-examined. He, via his lawyers, told the court that he felt like he was having a heart attack and he had actually gone to hospital. The father had been cross-examined for some time before the court made these interim orders. One of the issues the court had was that following separation, the father took the child to report allegations of SA perpetrated by the mother. The police investigated those allegations and ultimately and eventually they found that those allegations were not substantiated. So let's take a look from the beginning.
The case is Alul and Castelli, and you can view the entire judgment for free using Ostley.
I'm reading directly from the judgment. These are short form reasons pursuant to section 69ZL of the Family Law Act in respect of oral application for urgent interim parenting orders, which is brought by the ICL, the Independent Children's Lawyer, during the course of the final hearing and supported by the mother of the child, who is referred to in the judgment as Q, who was born in 2012. The proceedings, of course, concern Q, who is the only child of the parties, who has been living with the respondent father since April 2019 and who has not spent any time with the mother since December 2022, despite interim orders providing otherwise. Today is the 5th day of oral evidence in the final hearing, which commenced on Monday this week. The father, who is the respondent, is currently under cross-examination. He has throughout these proceedings been represented by solicitor and counsel. The child court expert is yet to give evidence, as there are 2 supporting witnesses in the father's case. The proceedings will likely take at least another day of evidence, and if closing submissions are to be done other than in writing, then there will be an additional day for closing submissions. So that will mean that the proceedings may take up to 2 further court days. This morning, the father advised the court through his solicitor that he was not feeling well, or certainly not well enough to attend court, that he was stressed by the proceedings, and that he thought that he might be having a heart attack. The father subsequently not attended court, and after going to see his general practitioner this morning at approximately 10 a.m, he has since been taken by ambulance to the Y hospital. The court understands that the father is undergoing some tests as we speak. The father is on notice of the urgent interim application and he has been able to provide his instructions to his solicitor and counsel about opposing the application. During the oral evidence, over the course of the last 2 days, the father expressed a number of times difficulties in being able to remember things, including his own evidence, at times given minutes prior. And he also indicated that he has been very stressed as a result of the proceedings, and that is why he has not been able to remember things. He denied ever having difficulty with his memory. Before the court, in the interim application, as part of Exhibit B, are various reports from the father's psychiatrist, which indicate that the father has had a major depressive illness, which is long-standing and which predates the parties' relationship. The father had another child who's referred to as P, who is the subject child's half-sister, and she is 13 years old. The court notes at para 7 that the 2 children are very close and a change in residence will have some impact on that sibling relationship. The father makes some very serious allegations against the mother in these proceedings. He alleges that the mother had SA'd the child Q and that the child is at an unacceptable risk of harm in the mother's care. The alleged disclosures are contained in the father's affidavit in the final proceedings, and those disclosures are very vague, not only as to the time as when they were made, particularly the disclosures said to have been made in late 2017, early 2018, but also as to what the alleged SA is alleged to be. The disclosures are contained in paras 42 and 49 of his affidavit. The father has already been cross-examined about those matters, and the court has heard his oral evidence about that. The father took Q to the police to report the matter in early 2020, and before the court, in the interim application, is the COPS entries relating to the reporting in early 2020 by the child to the police of the alleged SA by the mother. In the substantive proceedings, the court has before it the record of interview between the child and the police, as well as the DCJ, the department, notes in respect of the alleged disclosures. The outcome of the report to police is that there was a provisional ADVO made for the protection of the child, which was later withdrawn after the police investigations and approximately 1 month after it was granted. The police have taken no further action in relation to the alleged SA by the mother to the child, as it appears from the evidence that the police came to the view that the disclosures were vexatiously made and that the complaint was a vexatious complaint by the father. Certainly, the complaint was not substantiated and no further action was taken by the police or the department in respect of those disclosures. Q has seen a psychologist in late 2021 after the alleged disclosures in late 2017, early 2018, and the disclosures in 2020 were said to have been made. No disclosures were made to the psychologist in late 2021. According to Exhibit D, Q made some very vague reference to being touched on his and being touched inappropriately to Dr. Z, Q's pediatrician. The court says at 13, those disclosures are at best vague. At 14, what Exhibit discloses, though, in support of the submission that the father has engaged in systems is evidence of the father, in essence, doctor shopping. For example, in mid-2022, the father has indicated to Dr. Z that he's in search for a psychiatrist because he believes one will offer him a higher care than a psychologist. Q had been having monthly sessions with a psychologist for 18 months prior to mid-2022, and as noted earlier, there was no evidence that in any of those sessions with the psychologist, Miss AA, that Q disclosed any allegations of SA. At para 16, the court has to consider in coming to a determination as to what is in Q's best interest, including on an interim basis, the matters set out in Section 60cc of the Family Law Act. Primarily, it is the risks which the parents are said to pose to Q that the court needs to determine. Having regard to all of the matters that have been raised in the proceedings, the court is particularly concerned as to what arrangements would promote the safety of the child and of each person who has care of the child, including safety from being subjected to or exposed to family violence, neglect, or other harm. At 18, the court has serious concerns that Q is at significant and unacceptable risk of psychological and emotional harm in the father's household. The court has serious concerns that he is at significant and unacceptable risk of family in terms of coercive and controlling behaviours that are the subject of evidence in the mother's case, and also are the subject of evidence in the substantive proceedings, including through oral evidence of the father. The court is not of the view that the mother poses an unacceptable risk of harm by virtue of the allegations of SA or otherwise if Q was to live with her or spend time with her, certainly not on an interim basis. This, notwithstanding the very strong views that have been expressed by Q in the family report about refusing to be observed with his mother, about the evidence of the child's reluctance to spend time with his mother in accordance with the interim orders, and by virtue of the fact that the child has in fact not spent any time with the mother for a period of approximately 2 years. The court has significant concerns about the father's parenting capacity and his ability to meet the needs of the child, in particular his psychological, emotional and developmental needs, but also his cultural needs. Certainly, the father has displayed significant impairment in his parenting capacity in being able to meet Q's psychological, emotional and developmental needs, in that he has not facilitated a relationship between Q and his mother, in that he has stood in the way of that relationship by placing demands on the mother in terms of how time is spent, where time is to be spent, and indeed insisting that time be spent in his presence prior to the orders of June 2022. The mother also makes very significant allegations of coercive and controlling behaviour by the father, including that the father has required her to engage in intercourse with him before he would permit time between the child and the mother. The court is satisfied, notwithstanding that the evidence has not yet closed, that the father did engage in such coercive and controlling behaviour, and that he did require the mother to have intercourse with him so that he would facilitate time between the mother and Q. The court finds that the mother is fearful of the father as a result of his coercion and control, and the court finds, notwithstanding that the evidence has not yet closed in the final proceedings, that the father has engaged in family against the mother, including threatening her safety, as is evident from Exhibit 8 in the final proceedings, being the audio-visual recording of the father threatening the mother while speaking to her for a period of 15 minutes. The relationship between the child and the father to date is of concern to the court in the manner that has been disclosed in the family report, is that the child being somewhat reserved in the father's presence and only being observed to be acting in a relaxed manner when he's with his sister.
Pause to read all the orders that were made here, but prior parenting orders were discharged. The court made interim orders for the child to live with the mother. The court made an interim order that the father was restrained from contacting the child's school. As I said, this was an interim hearing. You can see here that the matter is listed for mention on 9:30 a.m. on 13 November 2024. Just a reminder that interim orders will remain in place pending a final hearing. When final orders are made, the interim orders are no longer in place or enforceable. The final orders are. And you can see here that the court uses pseudonyms to protect the true identity of the parties.
Stay tuned for our next case review together.